Hi, my name is Amy Berquist, and I'm a senior staff attorney at the Advocates for Human Rights. I'm also vice president of the World Coalition Against the Death Penalty.
And I'm Lisa Borden, and I'm a staff attorney at the Advocates for Human Rights in International Justice.
The Advocates for Human Rights is on the steering committee of the World Coalition Against the Death Penalty, and in that capacity, the Advocates assists other coalition members with doing advocacy at the United Nations, writing reports, and doing other parts of that kind of advocacy to use the United Nations as a tool to press their governments to abolish the death penalty. This video is one in a series of videos we are preparing for members of the World Coalition to help build their capacity to engage in UN advocacy. The focus of this video is going to be different issues that you can cover in your reports to the United Nations about the death penalty. So it's meant to be an overview, kind of a sampler plate of the different topics you might want to talk about in your report. Now, not every topic is going to be relevant to your country and your context, but we want to give you a sense of the breadth of the different issues that you might want to address. So this will be a brief, speedy overview of the issues, and it will be up to you and the people who are helping you with your report to go into depth and provide the context that you can provide for your country's situation. So here are the topics that we want to cover with you in this training. First, we want to talk about the status of the death penalty in your country and what types of information you will want to provide in a report about what the status is of the death penalty in your country. Then we'll look at some specific issues that might arise in the pretrial context for people who are at risk of being sentenced to death. Then we'll look at issues specific to the trial itself. Then we'll look at post-trial issues, including detention conditions. And then we have a variety of other issues that don't fit neatly into the above categories. So that's the way we'll proceed with this training in addressing these various death penalty issues you might want to include in your report. So with respect to the status of the death penalty, some people will categorize countries as retentionist, abolitionist in practice, abolitionist, de jure, but it's important to sort of see what the sequence might be and where your country is along this sequence. So if a country is currently conducting executions and sentencing people to death, then that is definitely a retentionist country like the United States. It's continuing to execute people, continuing to sentence people to death. Some countries, though, are no longer carrying out executions. They haven't done executions for a certain period of time, but they continue to sentence people to death. So some people might say that that's de facto abolitionist or there's a de facto moratorium, but if they're continuing to sentence people to death, that's also something you want to flag in your report. In some countries, they're neither executing anyone nor sentencing anyone to death, but there are still people who are on death row. And we use that phrase on death row because in some countries, there's a special part of the detention system for people who are sentenced to death. In other cases, people are sentenced to death, but they're with the general prison population. But what we mean by that is there are people who are still under sentence of death who could be executed, but the country isn't currently executing anyone, isn't currently sentencing anyone to death. Then there are countries where the death penalty is still on the books. It's still a possible punishment, but there are no people who are currently affected. There are no death sentences that have been pronounced. There are no people who are under sentence of death, and there haven't been any executions. The next step in the process, and things might happen in a different order here, is that a country may remove the death penalty from the statutes or, if necessary, from the Constitution as well. In some cases, states will flip the last two provisions. So they might ratify the second optional protocol to the International Covenant on Civil and Political Rights first, and then remove the death penalty from the statute, or they might do it in the other order. But the second optional protocol is really that final step of solidifying a country's decision to abolish the death penalty. Another factor to consider is whether the country supports the United Nations General Assembly moratorium resolution. And that might signal a country's support for moving toward abolition or ratifying the second optional protocol. But a country might support the moratorium resolution and still have the death penalty on the books. So that provision might happen at different places in the sequence. But that's all important information for you to include in your report. Another set of information has to do with what the law says about the death penalty. So this is just looking at the criminal code, looking at the various statutes to see what they say about the death penalty. And the first thing we look at when we prepare our reports is what crimes are eligible for the death penalty. And we want to be able to list in the report all of the different crimes that could possibly lead to a sentence of death. And we typically compare those crimes to the international human rights standards, which say that to be a crime eligible for the death penalty, the crime must be under the category most serious. And the way the United Nations Human Rights Committee has interpreted that phrase most serious is to say that the person sentenced to death or at risk of being sentenced to death must have committed an intentional murder. So drug possession, drug trafficking crimes don't rise to the level of most serious. And people who are involved in a crime where somebody died, but there was no intent to murder on the part of the defendant, that also doesn't rise to the level of most serious. So we will in a report typically list all of the crimes for which the death penalty is a possible punishment. And we will flag those crimes that are not most serious. Because we want to bring attention to that. We, in our advocacy, want to, in addition to calling for abolition of the death penalty, call for reducing the number of crimes for which the death penalty is a possible punishment. We will also look at the definitions in the crimes to see whether they are vague. And oftentimes there are crimes such as terrorism or treason or offenses against the state, for example, that are very vaguely defined, but are also eligible for the death penalty. And in a lot of contexts, the government will use these crimes as a way to target political opponents, for example. But we first just look at the statute, look at the language describing the crimes for which the death penalty may be a penalty. Another category that you'll look at under the law is what does the law say about who can be sentenced to death, who is eligible for the death penalty. An important topic to consider is juvenile offenders. We would look at whether the law allows anyone who was under the age of 18 at the time the crime was committed to be sentenced to death for that crime. And so we call those people who were under the age of 18 at the time the crime was committed, we call them juvenile offenders. So does the law allow people to be sentenced to death for juvenile offenses? That violates international human rights standards under the International Covenant on Civil and Political Rights and the Convention on the Rights of the Child. Another topic that is relevant is whether the law would allow pregnant women to be sentenced to death. And you'd also look at whether people with certain disabilities can be sentenced to death. People with psychosocial disabilities, intellectual disabilities, and developmental disabilities, for example, and we'll talk about those more at the end. But that's important information to provide if there are provisions that say that certain categories of people are exempt from the death penalty or whether there are no exemptions whatsoever. Another important aspect of the law is whether the law mandates the death penalty for any particular crimes. So in some countries, for example, murder is a mandatory death penalty. If somebody is convicted of murder, there's no ability on the part of the judge who's deciding the sentence. They have no discretion to sentence somebody to something other than death for the crime of murder. In other contexts, in some countries, if you're caught with a certain quantity of drugs, the death penalty is mandatory. And so take a look at the statutes and make sure that you've assessed whether the judge always has discretion whether to sentence somebody to death or not, or whether the death penalty is in some contexts mandatory. And if it is mandatory, that's an important concern to raise in your report. You also want to provide in your report sort of facts and figures for the relevant reporting period. So for the Universal Periodic Review, you're looking back to the previous Universal Periodic Review, so the last 5 years. And for a treaty body report, you're looking back to when the last reporting period was, when the concluding observations happened, or when the treaty was ratified by the state party. So you want to tell in the report over the reporting period, how many executions have taken place, how many people have been sentenced to death, how many people are under sentence of death or on death row, if there have been any exonerations, give the number of exonerations, and also if you can look up information about the United Nations General Assembly moratorium resolution votes, sometimes that can be useful information to include as well. So those are the sorts of facts and figures that we like to include in every report just to give a snapshot of the status of the death penalty for a particular country. Next, we'll move on to pretrial issues, and there are a few topics that we want to cover on pretrial issues. Maybe I'll hand it off to Lisa to take your pick and talk about whichever ones you want to, and then I'll fill in the rest. And Lisa, I think you need to unmute yourself.
In terms of access to counsel, there are both questions about whether or not people are provided counsel at all, especially people who are not able to afford to pay for their own counsel. But then there are also questions about when counsel is provided and the effectiveness of their counsel, whether the counsel are qualified and appropriately trained. So you always want to look for whether or not people have been provided with not only with counsel, but with adequate counsel very early on during the case, whether they have had access to counsel when they're being questioned about the case before they're being charged, whether they have had access to counsel during pretrial proceedings and to prepare for their trial, as well as whether or not they've had counsel at trial. And this relates to what you see there on the bottom as well, a quality of arms, because you want to look not only, and we'll talk more about that later, but you want to look not only at whether counsel has been provided, but whether the counsel has been given adequate resources to do their job. Another thing I'll mention is the issue of consular notification. The Vienna Convention on Consular Relations provides that for countries that are party to it, when a foreign national has been arrested or charged with a crime, they are supposed to be promptly notified that they have the right to communicate with the consulate of their home country, and then if they so request, the consulate for the home country is also supposed to be promptly notified of the situation. And very often that doesn't happen, or it doesn't happen until much, much later in the process. So it's really important to look to see whether that is being complied with for people who are foreign nationals in the country where they were charged, and whether or not they have been allowed to receive the assistance that their consulate is trying to provide. And many consulates do engage in some pretty robust assistance for their foreign nationals who are charged with crimes, especially with crimes that are associated with the death penalty. Amy?
Thanks, Lisa. Another aspect that you may want to raise is whether there is evidence that authorities engage in torture or cruel, inhuman, or degrading treatment, that's CID on the slide, when they're questioning people. And when they're questioning not only the person accused of the crime, but other people who might be witnesses or who might be coerced into providing evidence that could be used at trial. So this, at the pretrial stage, it's important to take a look at whether there is credible evidence that authorities engage in torture or other ill treatment of people when they're conducting investigations. So that can be relevant evidence to bring in. And you might say, well, I can't find any specific evidence related to death penalty cases. That's all right, because any use of torture or cruel, inhuman, degrading treatment during the investigation stage undermines the fair trial requirements that apply across the board for criminal proceedings, but also for death penalty proceedings. There are heightened standards for fair trial and due process. And so the use of torture and ill treatment in investigations really undermines the credibility of any judicial proceeding where somebody is at risk of being sentenced to death. Another topic you may want to cover, and this can have to do with foreign nationals or also with people who don't speak the dominant language in a country, is access to interpreters. So access to interpreters during questioning, access to interpreters to be informed of the charges, access to interpreters to be able to communicate with counsel, and access to interpreters during hearings as well and in preparing for trial. So that might be an issue in your country. Pre-trial detention conditions may also be relevant in some cases, including in the United States. Sometimes people who are charged with death-eligible crimes are housed on death row housed with people who have already been sentenced to death. And that can create the impression on the part of judicial officers and people who are in the detention facility that somebody has already predetermined to have been found guilty and that it's sort of their fate is to be sentenced to death. But you may also look at other detention conditions in terms of crowding, in terms of whether the conditions of detention are such that a person is not able to help prepare their defense. So that can also be relevant. Another topic that might be relevant to your country is the issue of blood money. In some countries, the law says that if a person, for example, has been murdered, the victim's family members can sort of call the shots about what will happen in the criminal proceedings. And the family members may say, we agree that this person shouldn't be sentenced to death if they pay us blood money. And, you know, generally speaking, any opportunity to avoid a death sentence is a good thing, but that may also raise concerns about socioeconomic status. So if, for example, the family demands a high price for someone to escape the death penalty, then it's only defendants who have access to those resources or who can tap those resources in the community who will be able to partake in that alternative to the death penalty. So that might also be a relevant topic to raise in your report. Anything to add, Lisa, before we move on to trial issues?
I can't think of anything else.
Okay. So now we'll jump in and talk about trial issues. And again, this is just an overview. There are a lot of different topics that might be relevant to your country's situation. But let's jump in and take a look at what we have for issues related to trial. Lisa, why don't you start us out, and I'll play cleanup after you've tackled some of these topics.
In terms of access to and quality of counsel, there are very many issues concerning quality of counsel that you might want to take a look at. In terms of first starting with whether or not there are any qualifications that are required for people to be appointed as counsel in death penalty cases. In some countries, and certainly in the United States, in some states, there's very minimal requirements for someone to be appointed to represent a person who's charged with a death penalty offense. So you find that lawyers who have a law license but whose practice doesn't involve death penalty cases and who therefore don't have the really significant experience that one would need to do it properly get appointed to represent poor people in death penalty cases. So looking at what does the state require, if anything, of people who are going to be appointed to represent people in death penalty cases is an important issue. You also want to look to see whether or not the courts adequately address cases where the counsel who've been appointed to represent someone make very significant mistakes. Do the courts allow those mistakes to be addressed properly in the appeals process, or do mistakes wind people up on death row and there's no adequate recourse to correct those mistakes? Those are very important issues. You also want to look at the court itself and how the whether or not the judges and the court system are fair and impartial and independent of other branches of the government. So if you're in a country where, for example, the courts are controlled by another branch of government, especially in the case of military courts, this affects their ability to be independent and make decisions that aren't going to be controlled by that branch of government. So you want to take a careful look at how are these courts, how are judges appointed, what branch of government controls them, how are the courts funded, and then in some cases, and this is an issue again in the US that we see in some states where judges are selected by popular election, and therefore they may have an incentive to present themselves as tough on crime and really want to amass a death penalty record, and that can be a very difficult thing to overcome in a death penalty case. We also mentioned here the issue of jury bias. So not only can the court system at large or the judge in a particular case be biased or have improper influences, so too can juries be biased in the sense of for example, racially imbalanced juries that are heavily white, for example, when the defendant is black. Or you can also have issues where jurors can be biased by media attention to a case that they're not being shielded from, or issues where jurors have access to social media, for example, and are able to be interacting with the public about a trial during the trial of the case. And those things can have really very difficult impact on the outcome of a trial. We also mentioned here evidentiary concerns about prosecutorial misconduct and police misconduct. And these are cases where either the police have engaged in some influencing of witnesses, or even sometimes it's, can be planting of evidence or hiding of evidence. Prosecutors may not turn over evidence that could help exonerate the defendant. Prosecutors may pay witnesses for their testimony, or otherwise make deals with people who are also in criminal trouble that influences their testimony. So these are the kinds of misconduct issues that you would want to look for in your situation. Amy?
Thanks, Lisa. We mentioned interpreters at this stage as well, and similar issues at the pretrial and trial proceedings, that the defendant has the right to an interpreter. Also, any witnesses who might not speak the language that the court uses need to be provided with an interpreter, and it's important to assess the quality of interpreters as well. The people who are testifying and the defendant should be able to communicate in the language they're most comfortable in, the language where they're best able to communicate. So it's an important consideration in some countries, in some contexts. I wanted to talk again about torture and ill treatment. Not only is it an issue to raise at the pretrial stage, but international human rights standards say that evidence obtained via torture and ill treatment should not be admissible at trial unless it is a trial against the person who is alleged to have committed the act of torture or ill treatment. So in a criminal proceeding against a defendant, if there has been torture, or if there are allegations that torture was used to extract a confession, for example, or to coerce someone into providing certain testimony, there needs to be a procedure in the trial proceedings or before the trial for excluding that evidence. So think about your context in your country and whether that's a relevant concern for cases in which somebody is at risk of being sentenced to death. Another issue that occurs in some countries is the use of mass trials, in which tens or more dozens of people will be tried at the same time for the same, for similar crimes or for related crimes, and no individual defendant receives a fair hearing because they're tried en masse. That can be a concern that we would raise in our UN reporting. Public trials are also an issue, and public trials are a good thing. People have a right to have a trial held in public, so it's important that the public, including the media, can access the trial, can observe the trial proceedings, unless there's extremely sensitive testimony. But the default should be that the public is allowed to attend the trial, that the media are allowed to attend the trial, and that everything is transparent so that people know what's happening in the judicial proceedings. So those are all factors to consider to look at your country's context and see whether these are a concern in capital cases or in cases when somebody is at risk of being sentenced to death. But now we'll switch and return to the topic of equality of arms. It's an issue both at the pretrial stage and at the trial stage, and I'll let Lisa talk a little bit more about how equality of arms can be relevant at trial, and what issues to look out for as you're thinking about issues to include in your report to the United Nations.
So in terms of equality of arms, I already mentioned about the compensation of counsel. You often will see situations where counsel may be appointed for someone who can't pay for their own counsel, but the compensation for that counsel is very low. This may mean that they don't spend a very many hours preparing for trial because they got too many cases that they need to work on for very low rate pay. and that very much hurts preparation for trial. But in addition, in order to try a death penalty case properly, there needs to be typically access to a lot of expertise in terms of investigators, forensic experts, for example. There may need to be a DNA expert. There may need to be, in a case that involves a gun, there may need to be ballistics experts who can testify about whether or not a bullet matches the gun that was found on the defendant or something of that nature. Prosecutors tend to have not only a fairly substantial budget, but also they have access to state resources. So they may have access to the DNA and forensic experts who work for the state. They don't have to come out of their budget to be able to utilize the services of these experts. But the defendant often doesn't have that kind of access. They may have to go to the court to ask for funds to hire experts. They may or may not be granted those funds, or they may be granted very little. So the imbalance between the resources that are available for the state and for the defendant can really be a huge disadvantage in these cases.
Lisa, can you talk a little bit about mitigation evidence as well? I think some people might not realize in a lot of contexts, including in the United States, there's the first stage of the trial is determining guilt or innocence, and the second stage is determining what the appropriate penalty is. And at least in the United States, that's also an opportunity for presenting evidence. Can you talk a little bit about mitigation and how equality of arms might be relevant in that context as well?
Absolutely. Again, there's a need not only for the services of investigators, but also for experts that are typically social workers, psychologists, neuropsychiatrists, people who deal with issues of psychosocial disability, intellectual disability, or developmental disability, who can dig into the story of a defendant's life from the time they were a child, and maybe raise issues of various kinds of disabilities, raise issues about childhood abuse, and those kinds of things that can affect how a person acts later in their life. And these experts are able to take that information about a defendant's early life and explain the story of the defendant to the decision maker, whether that be the judge or the jury. And without the ability to hire those kinds of experts to explain that information, a person who's been found guilty of a capital crime is much more likely to be sentenced to death. I will say too that this is not only, these kinds of experts also can be very relevant at trial or even in pretrial situation, because a defendant, for example, who has a very significant intellectual disability under the country's law may not even be eligible for the death penalty, but you need the right kind of expertise in order to show that to the court. So the counsel has to be able to have access to that expertise. Similarly, during the trial, a person's disability may affect whether or not they were able to form the requisite intent to commit the crime. So there are a lot of stages at which these kinds of experts are also very, very important.
And it goes back to the issue of quality of legal representation as well, because often, especially for an inexperienced attorney who hasn't been through a lot of death penalty cases, they're focusing on the guilt and innocence phase. That's the evidence that they're gathering. That's where all of their attention is. And oftentimes, as soon as there's a guilty verdict, the trial proceedings go directly into the sentencing phase. And an attorney can be caught off guard, can be said, wait, I need more time. I haven't done the investigation into my client's history. I was really focused on the facts of the charge in the case. And so that's another reason that having qualified counsel who are experienced in capital cases is particularly important, because they might not know otherwise that they need to be building out this entire defense for the entire proceedings, not only for the guilt and innocence stage. All right, well, we'll move on now and talk about post-trial issues. So assuming that somebody has been sentenced to death, what are the additional issues that can arise that might be relevant for your country's context? Lisa, let's let you lead it off again, and I can fill in the gaps where you leave off.
Yeah, as Amy mentioned earlier, it's in some countries, people who are sentenced to death may be housed with general prison population, while in other countries they may have separate death row situation. Oftentimes, if there is a separate death row, it will be along the lines of solitary confinement. It'll be single-celled environment where people are locked in their cells most of the time. So you want to look at the issue of how much of the time people are kept in their individual cell, how much time they're allowed to be out and interact with other people, even if it's only the other people on death row and the prison staff. Um, in the Mandela rules, which we've mentioned here, talk about the what constitutes solitary confinement, and in general, that's considered to be any place where people are confined to their individual cell more than 22 and a half hours per day. And when you're thinking about the amount of out of cell time someone receives, you want to be sure that you're not counting in that when you're trying to figure out whether it adds up to that amount, that you're not counting that time where people are just dealing with the basic necessities of life. So you're not counting the time that they're out taking a shower, or the amount of time that they are going to a medical appointment or something like that. The time that they're allowed to be out of the cell should be counted as time where they're allowed to interact with the other prisoners, play cards or anything like that, or where they're engaged in structured activities that are designed to help their mental health and keep them from being debilitated by all this time on their own. Access to healthcare in prisons is a very significant problem around the world. And by healthcare, we mean not only physical healthcare, but also certainly mental health care and even dental care. All of those things are, if you are going to keep people in prison, then you have to provide them with the basic necessities of life, and that does include all of these types of healthcare. So looking at whether or not people are able to get their basic healthcare needs met is an important issue too.
And I'll add, the Nelson Mandela rules say that whatever healthcare is available for the general population outside the prison, that's the level or the standard of care that should be provided in the prison as well, free of charge to the people who are incarcerated. So it's important to say you don't have to have like the fanciest healthcare in the world. It just has to be something equivalent of what is available to people who are outside the prison. Sorry to interrupt you there, Lisa.
Oh, no, not at all. Accommodations for people with disabilities, again, in many countries, including certainly some places here in the United States, prisons can be very old and dilapidated. And while that makes difficult conditions for everyone who has to live there, it's especially often difficult conditions for people with disabilities. And talking about things as simple as, there being stairs and doorways that can't be navigated so that people can't access even the spaces and services that are made available for other prisoners. People may not have access, people who have difficulties with sight or hearing, for example, may not be provided with reading material that they can use, or may not be provided with sign language interpretation, or other kinds of accommodations that would help them be able to hear. So again, things that are available for people outside of prison need to be available for people inside of prison. And they need to be, prisons need to be modified if necessary in order to allow people with disabilities to be able to access the services that are available to everyone else. Certainly you want to look at the issues of whether prisons are clean, whether they are taking appropriate steps to prevent infection control or spread of infection. Of course, that's all top of mind for all of us right now during COVID-19, but even without a pandemic, there are often in prisons serious issues of infections that spread throughout the prisons because proper conditions or proper steps are not being taken to prevent that. So for example, tuberculosis is a very big problem in a lot of prisons. Things like scabies are a big problem in a lot of prisons, and there are steps that prisons can take to prevent these things from being spread. an issue about, there are a number of issues about visits from counsel and family. One is where people are housed, because if people are taken to prisons that are very far removed from their family or from their counsel, they may have very hard time accessing visits, and especially if it's their counsel that's having a hard time accessing them, it may be difficult for them to prepare for their appeal, assist their counsel with their appeal. But also visits from family are very important for maintaining the mental health of someone who is in prison, and they need to be able to access. So you want to look at not only where they are housed in terms of distance, is that being considered, but then are prisons facilitating the appropriate visits from counsel and family? Are they allowing, especially for counsel, are they allowing confidential visits? And if personal visits, again, during a pandemic, if personal visits are not able to be provided at a particular time, are they providing adequate alternative ways of contact? Is there telephone contact available, and is that confidential for counsel? Those are important issues. We've already talked a bit about solitary confinement. I would say that another thing to look at for solitary confinement is whether or not the prisons are providing adequate monitoring of the condition of people who are being held in solitary confinement, whether they're holding people in solitary confinement for prolonged periods of time. And by prolonged, generally we mean any time more than 30 days starts to become a prolonged period of time and is very detrimental to people's mental health. Amy, any other thoughts?
And I believe the Nelson Mandela rules say that if somebody is being held in solitary confinement, they are to be visited by independent medical personnel on a daily basis to monitor their conditions. So that's another important thing to consider. There are a lot more potential things to talk about detention conditions. So I really recommend you take a look at the Nelson Mandela rules. These are the minimum standards for detention conditions. They're not specific to death row or capital cases, but there's a lot of detail in the Nelson Mandela rules. One issue that came to mind as Lisa was speaking is people who are subject to a death sentence should have access to the same vocational and educational training as other members of the prison population. So there are some states in the United States, for example, that have denied people who are under a sentence of death, denied them access to educational classes, for example, or vocational training on the grounds that such programs are not consistent with the sentence. Why should we train you for a profession? Why should we give you an education? Because we're going to ultimately be killing you. So those types of standards, those barriers to accessing programming at the detention facility also violate the Nelson Mandela rules. So it's important to take a look at these standards. And again, if your country doesn't have a separate death row, if the people who are under sentence of death are housed with the general prison population, you can talk about all of the detention conditions generally in your report, because they are just as relevant to the people who are under sentence of death. So don't feel like you have to shy away from those issues if you don't have a specific death row, or if you don't have specific information about people who are on death row. Another topic that has to do with detention conditions is what's sometimes referred to as death row phenomenon. And this is something that's been recognized by the Privy Council, if your country is part of the Privy Council jurisdictions. It's a determination that after being on death row or being under a sentence of death for a prolonged period, that simple act of being under, having your death imminent, having this death penalty looming itself is a form of torture or ill treatment. It's a form of psychological pressure on a person that is something worthy of note in and of itself. So even if a country isn't currently executing anyone, even if there's a moratorium on executions, if there are still people under sentence of death, death row phenomenon is something that you may want to raise in your report. There are other issues related to a person's right to appeal and seek clemency. So with the right to appeal, first of all, in some countries, a person does not have a right to appeal. There's no right to appeal for certain offenses or in certain court proceedings, but you'll want to take a look at what the right to appeal is in your country's context and whether there are any limitations on that right to appeal under law, or in practice, whether there are limitations on the right to appeal. So Lisa, do you want to talk about some of those concerns that might arise with respect to the right to appeal?
Yes, in terms of access to counsel, um, we've talked about the right to have counsel for your pretrial and trial proceedings. People also should have access to qualified counsel for their appeal. But one thing that we may not think about is that it can be important to have access to different counsel for your appeal because of the next issue, which is about defaulted claims. If your counsel who was appointed to represent you at trial did not do a good job or made some significant mistakes, that person may not be the right person to raise those things on appeal. They may not want to raise their own mistakes on appeal. So therefore, having access to counsel who can freely raise all of the things that trial counsel did wrong is a very important issue. In a lot of countries, and certainly in the United States, this is an issue. If you fail to raise issues in your appeal, then you default on them. You can never raise them again. So that makes it especially important to have counsel in your appeal who will raise all the mistakes that were made at trial, because if they're not raised then, they could be forever barred from being raised in the future. So that's an important thing to look at. I would say also this issue of exonerations, I think we've learned recently we're over 172 exonerations in the United States, and people around the world often are wrongly convicted of capital crimes and may spend years or decades in prison for crimes that they did not commit. And the appeal process, obviously, and any post-appeal court processes that are available to ferret out the evidence that finally exonerates someone, obviously extremely important. And the access to counsel for all of those steps of the process is very important. In the United States, for example, people do have a right to access to counsel for their direct appeal, but once those appeals have been exhausted, if there's future litigation, say new evidence arises and they want to go back to court and present the new evidence, there is no right to counsel for those kinds of proceedings, and may make it impossible for someone to properly raise them. So looking at access to counsel for every possible court process is important to do. We also, in the context of exonerations, we want to look at whether or not there are any remedies at the end of the day for people who are found to have been wrongfully imprisoned for a capital offense. Oftentimes, people may have been in prison for decades. They obviously don't have current job skills. They may not have a place to live. They may have no way to support themselves. They may have been denied education, as Amy mentioned. So is the country providing not only any compensation to them for all the time that has been stolen from them, but are they receiving support in order to be able to re-enter society? Are they, in order to be able to find a job or to find housing, and also support for their mental health, because obviously it's a very traumatic experience to have gone through, and people will need support for their mental health as well.
And another aspect of remedies has to do with accountability. So if there has been prosecutorial misconduct or misconduct on the part of the police, what does the right to appeal mean? Does it just mean that, okay, you get to have another trial, or is there any mechanism in the judicial system for holding people accountable for the for depriving the defendant of a fair trial in the first place. So that's another sort of important thing to think about in your country's particular context. Are there ways to hold people accountable who are part of the prosecution team or the judicial system or law enforcement for misconduct that they engage in? Another issue is the right to seek clemency or pardon from some executive authority, and there's no right to receive a pardon or to receive clemency, but it's important to look at whether, first of all, whether anyone is barred from seeking clemency or pardon. In some countries, if you're convicted of a particular crime, you're ineligible for a pardon or clemency. But another thing to look at is the transparency of the process. It should be clear how a person goes about seeking clemency or a pardon, what steps they need to go through, and that process should be transparent. So that might be another thing to look at in your country's context. The final issue at this stage is to look at retroactivity. So if there is a judicial decision that is in favor of somebody who has been sentenced to death, but not in their particular case, does that decision apply to them as well? Do they get the benefits of the change in the law? And that's an important aspect of international human rights standards, that criminal defendants should get the benefits of any change in the law or in the interpretation of the law. At a minimum, they should be eligible, for example, for resentencing. If the country had a mandatory death penalty and that mandatory death penalty is struck down, then anyone who had been sentenced to death based on the mandatory death penalty should be eligible for at least a resentencing hearing and should have access to evidence for that resentencing hearing so that they can present evidence in mitigation. And this might be decades later after they've been sentenced to death, and the initial trial court may never have considered mitigating evidence. The attorney may not have presented it because it was irrelevant, because the death penalty was mandatory. So there was no need for the court to look at any evidence. And so it might be decades later that the defendant then needs to have the support, the access to counsel to gather that evidence, to present it in a resentencing hearing. So it's important to think about retroactivity and how that might play out in terms of the right to a fair retrial or rehearing of the evidence as well. Anything more to add, Lisa, before we go on and talk about notification issues?
No, I don't think so.
Okay. So then as we get closer to the execution itself, there may be issues with respect to notification. So certain people should be notified of the date of the execution. Most important, the person who is scheduled to be executed should be given timely notice of the date of execution. There is at least one country I'm thinking of where they don't inform the defendant that he or she will be executed until the morning of the execution itself, with the justification offered that this gives the person peace of mind. But of course, that means that every knock on the door every morning could mean that this is your last day on earth. And so it can actually be quite traumatic for people to live in that constant state of uncertainty. So there should be advance notification of the date of execution to the person who's scheduled to be executed, also to their attorneys and to their family members as well, so that they know that this execution is imminent, and can prepare themselves psychologically and prepare any last-minute legal appeals and all of that. After execution, there's also a burden on the state to provide notification to the family so that the family can access the body, or if the body has been buried, the family has the right to be notified of the location of the burial. And there should be transparency to the public as well about that the execution has taken place. In some countries, there's a lot of secrecy about death sentences and about executions. In other countries, there's a lot of publicity about them, in some cases because for political reasons. Anything to add here, Lisa, before we look at methods of execution?
No.
All right, so now we're going to talk about methods of execution. Lisa, I'll let you take on whatever you want to take on, and then I'll cover the rest.
So in terms of the methods of execution that may constitute torture or cruel and inhuman treatment, in some countries, of course, stoning and crucifixion are used. In the US, there used to be electrocution. Now, the US uses lethal injection. And there's been a lot of controversy and litigation concerning the use of lethal injection in the United States because initially most of the litigation was about the suffering that the lethal injection process could cause because it first renders the person unable to move or speak and then can cause tremendous suffering, but the person is not able to usually demonstrate that, although there have been cases in which it's been very apparent and taken a lengthy time. But since then, what has happened is that drug companies, the drug companies that normally make these drugs as medication have determined that they don't want their drugs to be used for carrying out executions, and they've stopped making it available to states that want to use it. So in many cases, what's happened is that the states have then gone underground and started using compounding pharmacies or other kinds of providers of these drugs that they try to keep secret so that they can not have their pipeline of drugs cut off again, but also so that there can't be any scrutiny of the purity of the drugs that are being used, whether they're expired or not, and if they're using drugs that are impure, that have been made improperly, or that are long since expired. This may also lead to unnecessary suffering when they're administered. So those are the kinds of issues, regardless of what method of execution you're looking at. You want to look at the issues about what kinds of suffering can be inflicted before the person dies from the execution method. You want to look at whether or not these things are being carried out in secret so that the public is not able to know what kind of suffering is being inflicted, whether or not that's being hidden from view, not only from the public, but also from victims, the defendant's family, from experts who may be able to provide testimony about it.
In some cases, and it doesn't occur very frequently, but in some countries, under the hudud offenses, the victim's family member is supposed to actually carry out the execution. So if it's a hanging, the victim's family members are supposed to be the ones to kick the stool out from underneath the person's feet, or drop the platform to let the hanging happen. And that can also be a human rights violation with respect to those family members who may not want to play such a direct role in the execution. So that's another topic to look out for. Public executions are also a human rights concern. There should be observers to an execution, but in general, public executions violate international human rights standards. They violate the dignity of the person who is being executed. And in some cases, governments, announce and encourage people to attend these executions. Children will witness the executions, and then you will hear anecdotal evidence of children playing execution then in the playground with their friends, and in some cases accidentally killing each other because they're imitating what they've seen, as children often do. So that would be an important issue to raise if your country has public executions. Access to counsel is also an issue with respect to the execution itself. It's important that legal counsel are able to be present during the execution and in the time leading up to the execution. In many cases, they have filed last-minute appeals, and so it's really important that they be able to communicate freely with their client and with the courts where the appeals are proceeding. So that's very important. There was an execution recently in the United States where legal counsel was sent home. They said the execution was called off, and they then reversed course and went forward with the execution without legal counsel being present, and that's obviously very concerning. Anything more to say here, Lisa, before we jump over to other issues, our sort of potpourri of additional topics? All right, so we've collected at the end some issues that didn't fit neatly in one category or another. So this is the sort of collection here, and there might be additional issues in your country's context that aren't here. If you have any questions, you can certainly reach out to us and we can talk through it. But I'll talk about a few topics, and some of these are topics that we have addressed on World Day Against the Death Penalty as sort of themes for World Day. We had a theme last year of children of people who are sentenced to death or executed. And here we're talking about children who are under the age of 18. You may want to talk about whether those children have the right to visit their parent who is scheduled to be sentenced to death. You could talk about the psychological effects, the trauma that children face if their parent is sentenced to death or if the parent is executed, whether the execution or the sentence is in the best interest of the child, which it of course is not usually in the best interest of the child for them to have a parent who is executed. But that best interest of the child standard is in the Convention on the Rights of the Child, and that's an important topic to address if any of the people who are under sentence of death in your country have minor children. They may also face other consequences because of the death sentence. They may be deprived of a breadwinner in the family. They may be subject to teasing or ostracization in school or in society. So there are a variety of issues that you can raise in that context. Women and the death penalty. This will be the 2021 theme for World Day Against the Death Penalty, and there are a lot of gender-related issues for women who are sentenced to death, for example. They're often sentenced to death for crimes that have to do with gender roles that are discriminatory. If a woman does not comport with traditional gender behavior, she's more likely to be sentenced to death based on allegations of that nature. And courts are sometimes not good at looking at self-defense, for example. If a woman murders her domestic abuser, courts will nonetheless, in some cases, sentence the women to death for that offense in some countries without taking into account the broader context of the reasons for that killing to have occurred. So there are a lot of gender-related issues you could address. I highly recommend the Cornell University's Center on the Death Penalty report that they did on women and the death penalty. It covers a lot of different issues in different countries that might be relevant to your report. Socioeconomic status is another topic that we've covered on World Day Against the Death Penalty. We mentioned it in terms of hudud offenses and blood money. It's also, of course, highly relevant for quality of counsel and access to counsel. For people who come from disadvantaged socioeconomic status, they may not have access to high quality legal counsel to ensure that their fair trial rights are respected throughout the proceedings. And people may be engaging in certain conduct that is related to their socioeconomic status. So they may be transporting drugs because they have no other way to support themselves. And for countries that impose the death penalty for drug-related offenses, it can have a disproportionate effect on people based on their socioeconomic status. Racial and ethnic discrimination can also be a topic to raise depending on your country's context. Certainly in the United States, there are vast racial disparities with respect to the death penalty, but in other countries as well, there may be ethnic discrimination targeting of foreign nationals, for example, for death-eligible crimes. There may be other aspects of discrimination that are present. Lisa, do you want to talk about people with disabilities a bit more?
Sure. As we mentioned earlier, there can be a lot of areas where people with disabilities can be at a significant disadvantage in terms of getting a fair trial in a death penalty case in particular. And that can be starting from the very beginning when people are questioned about their alleged offense. It can be at the pretrial stage where they may not have been given access to the appropriate expertise in order to show that their disability is an issue that needs to be considered, or their counsel is unaware that that needs to be done. Those are significant concerns. We talked about mitigation evidence, and in particular, disabilities, especially intellectual developmental disabilities, are very, very significant mitigation evidence that needs to be presented when someone has been convicted of a capital offense in the sentencing stage. And again, in terms of detention conditions, we mentioned a little bit about physical disabilities, but people with intellectual disabilities and developmental disabilities can be at a significant disadvantage in prison in terms of just their ability to navigate the conditions of their detention, their ability to stay safe from the danger that may be posed by other prisoners or even by correctional staff who take advantage of them. So those are all things that can be significant disadvantages for people with disabilities in death penalty cases.
Thanks. And the key thing to focus on, the terminology under the Convention on the Rights of Persons with Disabilities is reasonable accommodations. So there should be accommodations, whatever the disability. There should be accommodations in the judicial proceedings, in the detention facilities, and any accommodation that is reasonable to allow the defendant to mount a successful defense. So accommodations in terms of communicating with counsel and all aspects of trial. And that's one reason the World Coalition has opposed the use of the death penalty specifically for people with disabilities, is because these accommodations are not made. There are so many disadvantages, additional disadvantages they face throughout the proceedings, that we know that those proceedings are not going to be fair, and it is a violation of human rights to execute someone after an unfair proceedings. We talked, moving on to transparency regarding the method of execution and the sourcing of drugs. I think Lisa talked about that topic already. It's important for a defendant in a country that uses lethal injection to have access to that information. We also talked about remedies for exonerees, but just to add to that point, if somebody has been exonerated, they have been deprived of their liberty arbitrarily, and so there should be remedies, there should be compensation for that human rights violation. And in some countries, there's no remedy whatsoever, and in other contexts, in other jurisdictions, there are barriers to obtaining remedies. In some contexts, the exoneree has to prove that they did not play any role in their conviction. Now, we know that some people will confess to crimes that they did not commit. They will confess because they were subjected to torture or ill treatment or otherwise coerced. And this can be particularly relevant for people with developmental disabilities, for example, or intellectual disabilities. And so they may have, under sort of a strict legal view, they may have contributed to their conviction and may be disqualified from obtaining any remedies for the arbitrary deprivation of their liberty. So there are a lot of different issues related to remedies for exonerees, but also social support for exonerees, because they have endured trauma, being wrongfully convicted and wrongfully incarcerated for a prolonged period or even for a short period. And so there's a real need and obligation on the part of the state to provide healthcare, vocational training, other support services for reintegration. Ironically, in the United States, somebody who is released from prison after serving a prison term is provided with a lot of support from a parole officer to check in with and all of that, and somebody who is exonerated receives none of that support because they are no longer under the supervision of the court system, no longer under the supervision of the prison system, and so they don't receive any of the support that other people might receive. So they're oftentimes left out on their own, given $20 and maybe a bus ticket, and that's all. Lisa, do you want to talk a bit about regressive measures as our next topic on the screen?
Sure. Unfortunately, there are a number of countries around the world that are going backwards on the death penalty and are reintroducing, may have had a moratorium, or in some cases even may have abolished the death penalty, may have ratified the second optional protocol, but are moving back towards reinstating or expanding their use of the death penalty. These tend to be in the areas of either drug-related crimes, or terrorism-related crimes, where countries are expanding their laws to apply the death penalty to more crimes, or are reintroducing it where it's been abolished. And so if you are, it's very important to look and see what's the history of the use of death penalty in the country that you're looking at, and are they going in the wrong direction? If so, that's definitely something that you want to focus on and make sure is a significant point in your report.
Yeah, and that's very important to include, you know, even if it's just sort of saber rattling or political rhetoric, it's still important to include in your reports to the UN that there might be suggestions that the government is going to move toward reinstating the death penalty or adding additional crimes that might be eligible for the death penalty. That's all relevant to include in your report. The UN bodies you'll be submitting the report to will want to hear about that, even if nothing has been finalized, even if there hasn't been an actual change in the law. That will be relevant. And our last topic on the slide has to do with human rights defenders, people like all of you listening to this training who are working to abolish the death penalty. In some countries, in some contexts, they face persecution. They might face death threats. They might face harassment. They might face reprisals. They might face penalties from the government if they go to the United Nations and engage in advocacy. So it's important to include that information in your report as well. The UN human rights mechanisms want to hear about reprisals and harassment of human rights defenders, and particularly if it's a human rights defender who is vocal about the death penalty, they'll want to hear about any repercussions they are facing because of that important advocacy toward abolition. Anything more to add, Lisa, before I wrap us up?
Nothing else from me.
Okay, well, that is our overview of death penalty topics that you might want to include in a report to the United Nations. As usual, if you have questions, you can contact me. My email and telephone number are up on the screen. And as usual, I recommend that you consult our toolkit, Human Rights Tools for a Changing World, Chapter 9, as its focus, advocacy at the United Nations. But this will conclude this training video, and we hope to see you again for another training video soon. Thanks very much for your attention. Bye-bye.